So to introduce myself, I'm Jack Champagne. I spent uh, seven very important years in Pittsburgh for my college and also going to Pitt Law. Um, I've attended most of these summits. I found them to be a very valuable resource. Um, and as a Southern boy who sort of mistakenly ran away to Pittsburgh trying to escape the kind of racism I was accustomed to. I feel like I kind of owe the city a little bit in my sort of formation of my understanding of how race affects all of us. And so this is sort of my approach to giving back to the city some of what I got from it. Um, and I'm co-facilitating today with Sam. If you want to introduce yourself.
Hi everyone, my name is Sam Rocha. I am zooming in from Vancouver, British Columbia, Canada. Um, I'm a associate professor at the University of British Columbia, and I'm a Texan or a Tejano by birth and ancestry. And I also was close to Pittsburgh, but never quite made it all the way in. I was just over the Ohio River in the state of Ohio for undergrad, and so I have some fond recollections of going to Heinz Hall and getting student rush tickets to see the symphony. But at any rate, it's not as robust an engagement or a sense of debt as Jack's, but it's good to be here today, and I'm excited to share this session. And really, thanks to Jack for inviting me to join him here.
Absolutely. So this is meant to be a workshop on critical race theory. Um, we've kind of found ourselves in a sort of cultural moment where a lot of people who had never heard the word critical race theory have suddenly found it as a household name. There's been sort of a concerted effort on the part of people like Chris Bo, that has sort of leaked the mainstream to kind of tar critical race theory as this sort of subversive ideology that's infiltrating schools, that's being taught to your children. They're being taught Marxism. They're being taught how to hate white people, that sort of thing. We've kind of found ourselves in the fierce urgency of now, so to speak, to correct the narrative here. And there's no more appropriate place to do that than a racial justice summit here in Pittsburgh, where critical race theory was born.
Mm-hmm.
Um, Particularly in Pittsburgh Hill District, the historically Black Hill District, where Derek Bell, the lawyer and law professor who founded critical race theory, was born and lived most formative years. And that, I think, is probably the most important corrective that we could do here, is to uh, reestablish the place of Derek Bell, not just in the history of critical race theory, but also in the history of anti-racist abolition struggles, because he's been erased so completely from the picture. You hear all this talk about how the ideology of critical race theory is founded by Marx, uh, Cole, all these white European professors who never set foot in America, who knew very little about race problems in America, and yet this person who was so thoroughly formed by civil rights activism and then later by pedagogy around civil rights law was had constructed this theory as a way of criticizing what he believed was the flaws in our understanding of civil rights, our understanding of the way that it interacts with the law. So we kind of want to give you sort of a historical background on what critical race theory actually is, kind of explain what it actually teaches, and kind of give you the opportunity to have some hands-on experience with the type of pedagogy that Derek Bell himself tried to pass on to law students. What we hope for you guys to get out of this is an understanding of the way that critical race theory has been taught over the years, the way that it was taught to the original scholars who expanded outward critical race theory, and hopefully you'd be able to share this with others as time goes on. As you know, put we kind of educate you to educate other people.
And another part of the corrective I think that's important, obviously the place and the significance of the place in relation to this gathering is key, but it's also the time. If you notice the sort of timeline presented, obviously the Marx Nietzsche stuff is super ahistorical because they're talking about 19th century figures. Foucault, maybe you enter into sort of at least the 20th century. But the by and large, the critical race theory that's being discussed, and in some cases even defended, is largely the work of the late 1980s into the 1990s moving forward. And one of the real dangers of this is we lose the relationship between critical race theory and the civil rights movement and civil rights law. Um, and what we lose, I mean, in just crass historical terms, is the 1970s, which is precisely the decade after the 60s, the decade after 68, after the death of King. And the crucial role during that decade that was played by really a singular figure, being in this case Derek Bell. So this should hopefully not only remedy the narrative of characters and the narrative of places, but also the narrative of time, so that we can have a more fulsome understanding of how things moved from 68, 69, 70, all the way to the present. And by the way, the present, of course, is a reoccurring story of this kind of, you know, uh, white rage and directed at racial consciousness raising. There's no question that the relationship between the summer of 2020 and George Floyd and Trayvon Martin and how these impacts BLM and so on came to kind of irritate, you might say, a kind of status quo sentiment. So I think that the figure of time also here hopefully has a role to play.
Absolutely. We've been kind of given a popular narrative as far as the temporal arc of civil rights has gone. To the civil rights movement, in essence, starts in 1954 with Brown v. Board of Education, and kind of reaches its culmination with the passage of the Civil Rights Act, Voting Rights Act, and that we kind of move into a new phase where the struggles of the past have suddenly become irrelevant. Now, simply in the hearts and minds phase of anti-racist struggle. All of the institutional barriers have been destroyed. There's nothing left to do. We just need to convince people not to be racist. Is where we're often told we're at. And one of the insights that Derek Bell and critical race theory have presented to us is the idea, perhaps, that civil rights movement failed,
Mm-hmm.
not just in its supposed endpoint, but even from the very beginning. Um, which with Brown v. Board and Education, the early legal victories that sort of sparked the movement as such. So I actually wanted to start with something somewhat personal to myself. And I'm being asked to speak a little bit more slowly. Uh, that's absolutely something I do. I apologize for that.
Same here.
Sure thing. To accommodate the ASL interpreters. I'm sure that those of you who are hearing impaired are able to follow along with us. So, more than happy to do that. Okay, so I wanted to give you guys a quick poll without any background here. It's a relatively simple question. Do you think that the city of New Orleans was segregated? I do not know how many people are. Oh, wow, you guys are quick.
high participation rates.
Yeah. Yep.
Good data.
We got a good cross section.
Mm-hmm.
Give it a couple minutes. Have it. Uh, anyone just coming in? All right. So we have a pretty resounding no as the answer here. About 84% no, about 16% yes. This is kind of a trick question. It really depends on what question you're asking. We so the history of Louisiana is very interesting. Way that the desegregation decree happened and its residual effects on the school system, particularly as regards to New Orleans, simply because it is the population and cultural center of Louisiana. So just like everywhere else, Louisiana was ordered to desegregate in a series of cases that followed from Brown forward. This was virtually inescapable, despite a significant effort by the Louisiana state legislature to avoid this. They pulled out all the stops. They basically sparred with the federal judge in charge of it at the time, J. Skelly Wright, constantly um, renewing segregation laws that had been struck down as unconstitutional, inventing new ways to get around it, and things like that. But ultimately, this came to a head when a very wealthy plantation owner by the name of Leander Perez um, essentially bought and paid for a private school system that was parochial in nature and was essentially designed to allow white students to flee from newly integrated public schools. Not all of them by any means, because these were still private schools. Therefore, there was a price ceiling. But Leander Perez also did pay for a lot of the busing and the tuition for a lot of the schools. So this was essentially white flight times 100, right? Basically, you had a de facto desegregated school system, but by and large, you had an integrated public school system that was overwhelmingly black, um, because the white students had essentially fled to a separate school system, private school system, a parochial. Now you fast forward to today, and nowadays, the school system, the public school system in New Orleans in particular, but Louisiana as a whole, is still overwhelmingly black. It is about 93% black, which there's a lot of black people in Louisiana, but I can tell you it's not 90% black. There's something of a class divide there as well. Wealthy and middle class black people are more able to escape from the school system than for than obviously poor black families can. Uh, but this is particularly salient with the fact that Louisiana's public school system is failing, and it's failing badly. We were 50th in the country until New Mexico became 50th, which is the state I'm currently in. So I'm destined to be last in education the rest of my life, apparently. But the schools are essentially crumbling under the weight of their own neglect. Like the school buildings are literally crumbling. The educational materials are very far outdated. It's very difficult to retain full-time staff. Teach for America fellows have been picking up most of the slack, but they don't stick around for very long, and they're almost always inexperienced. And then, of course, Hurricane Katrina happened, and then the school system that was crumbling got almost destroyed. A school system that was almost entirely servicing poor black students. All of this is to say that New Orleans was, just like everywhere else in the South, formally desegregated, but substantively is very much still a segregated system. And one of the biggest issues in the way that we understand this in terms of our ordinary legal discourse around race is that it's very difficult to account for this disconnect between the formal desegregation of southern cities like New Orleans and the fact that we still see substantive segregation, substantive racism, which of course neuters the ability of the federal government to do anything about it. Because as long as the states remain compliant with the letter of Civil Rights Act and the constitutional decisions made around civil rights, they are still officially desegregated. They've done all that they need to do in terms of racial equity. We've achieved racial equity in that sense, and yet we still have this massive segregated system. So Derek Bell had firsthand experience with all of this. He was briefly after his graduation from UPenn Law, um, a staff attorney for the United States Department of Justice's Civil Rights Division, which he subsequently left in protest when they asked him to resign his membership in the NAACP, citing a conflict of interest. He from there went to the NAACP's Legal Defense and Education Fund, where he worked primarily under Robert Carter and Thurgood Marshall in their desegregation cases. Most prominently, he desegregated Ole Miss with James Meredith, which was a massive event. It eventually inspired Meredith to do his March Against Fear, which is one of the very first direct actions that Martin Luther King Jr. participated in, and so on and so forth. Um, so even while he was at the LDF, Derek Bell started to have misgivings about the overall strategy of the LDF, which was essentially to demolish the legal barriers to desegregation. The primary strategy, mostly in southern states, was to highlight the extent to which separate but equal, the Plessy v. Ferguson standard, was unworkable. States couldn't have two separate school systems that were too equal because it was simply way too expensive, and to essentially force them to desegregate by creating a legal standard that they could only make by integration. But Derek Bell was starting to have some misgivings about this. He discussed this primarily with regards to Brown v. Board, which he suggested was not doing what it purported to do, which was to achieve not desegregation, but educational equity for Black students. He just said that despite the legal standard here being that school systems had to integrate, that they were oftentimes given these integration degrees, they were given these integration plans, they were told you have to integrate. We were still seeing bad outcomes for Black students. We were seeing Black schools being the one that were being closed down. We were seeing students being bused long distances away from home that oftentimes negatively impacted their academic performance. Often because they were anywhere from 20 to 50 miles away from home. Their ability to participate in extracurriculars was very attenuated. So he was starting to ask the question, why do we have this demolition of formal barriers to racial equality, and yet we still have substantive racism in our society? How do we address that? How do we as a legal organization address that simple fact? And it's from asking this question that critical race theory essentially emerges as sort of idea.
And one of the examples we can see in Bell's analysis for this, kind of planting the seed of doubt into what has been more popular understood as a series of just victories, is the sense in which he questioned almost like the goodwill or the intent of constitutional law and of the Constitution itself. At one point, he writes, traditional civil rights law is highly structured and founded on the belief that the Constitution was intended, at least after the Civil War amendments, to guarantee equal rights to blacks. The belief in eventual racial justice and the litigation and legislation based on that belief. So he's focused really on like the faith or the belief um, of this contract of the Constitution was always dependent on the ability of believers to remain faithful to their creed of racial equality. If you notice his choice of language, he's almost casting this in an almost religious, psychological kind of analysis, while rejecting the contrary message, the false gospel, you might say, of discrimination that survived their best efforts to control or eliminate it. So he's posing this as kind of the fundamental core premise or the kind of religious condition, you might say, of the Constitution. And he's calling it out as being false. He says, despite the realist challenge, which is represents his challenge to racial realism, that demolished its premises, the basic formalist model of law survives. So Bell's issues obviously are taken up in the form of case law, in the form of civil rights law, definitely an ongoing, decades-long obsession really with the outcomes of Brown v. Board of Education, both diagnostic and also updates. Um, but he's also sowing doubt into the sort of natural religious convictions that the Constitution is, in fact, a good faith document. And I think, obviously, the reasons for that seed of doubt are all over the history of this nation. So it's not, I think, difficult to understand what his evidence is, but it shows, I think, how deep critical race theory questioned not only the sort of tacit laws and the legislation that was on the books, but even the core principles and belief structures that created our society as so. And I think it's really this aspect, not more so, but along with those ones, that planted a great deal of strong reactions from the very beginning to Bell himself and to critical race theory, and then definitely to his students. Because I think this is one thing that all the students of Bell and critical race theory today share, which is a fundamental skepticism that the Constitution can be trusted, that the nation's social contract is one that we can approach in good faith.
Yeah, this is essentially Bell carrying forward a very, very old debate within the legal academy. This is a debate between um, legal formalism and legal realism. Um, this debate is essentially older than the country itself. It really comes into the fore in the 1930s in the pre-World War II era, but it is as old as American common law itself. Legal formalism is the idea that when judges, when legislatures are are doing legal work, when they're carrying forward legal principles, they are simply applying the letter of the law as written. That the legal outcomes of cases simply depends on the law as written or the unwritten law that exists somewhere, the objective law space that the stuff exists in. And this has been the standard legal principle in this country for a very long time. You see it in appeals to constitutionalism and all of the founding fathers, in Abraham Lincoln, in Frederick Douglass, and a lot of figures in the post-Civil War era, the Reconstruction era. They have said, they've essentially said that we have changed the Constitution, we have changed our founding document. Therefore, the way that we interact, the way that the law interacts with people has fundamentally altered. We have essentially abolished constitutional racism by passing the Civil War, right? Then you get into the post-Reconstruction Jim Crow era, and that narrative has been okay. Well, the Constitution has changed, but that simply wasn't enough. There wasn't enough federal action to make that change happen. We are going to now take federal action to carry forward the promises of the Constitutional Amendment. And then you saw that with things like Brown v. Board. You saw that with things like the Civil Rights Act of '64. And you saw this with things like the Voting Rights Act. Um, and then Bell observes, this hasn't done anything either. This
And
has
I
done
think what
something, but it hasn't tackled substantive racism.
I think one metaphor to kind of imagine this that's really useful is a substantive understanding of what was King talking about when he talked about a bad check. King's metaphor of the bad check, or of the check that didn't have money in the account, was essentially the laws of the nation and the constitutional amendments after this, the Reconstruction amendments to the Constitution. And, so in many ways, Bell was putting a legal analysis and as a scholar, applying a legal, academic investigation into that metaphor that King planted so vividly in our imaginations at that speech of the bad check.
Yeah, he saw firsthand what
Hmm.
happens when you try to cash that check. Oftentimes,
I
it
mean, we
bounces
could,
and it bounces hard.
yeah, and we can even, I mean, I think what Bell, one claim, the sort of, I would say, kind of a liberal, critical legal studies claim is like, well, the structure of the bank is capable of giving, of cashing the check, of backing it. We need to find the mechanisms to make sure that that money is in that account. Bell goes further and he says, what if the bank itself is corrupt? What if this particular bank never intended to cash this check out? What do we do then, right? And that plants that seed of doubt much more deeper.
Exactly. The traditional enemy of legal formalism is legal realism, which suggests that the law is the law is in fact a sort of cloak over hidden values in decision makers. Decision makers make the kinds of decisions essentially that they want, and they simply are constructing a legal principle um, with that in mind. One of the probably the biggest figure in legal realism during that time period was Oliver Wendell Holmes, who famously said the life of law has not been logic but experience. In other words, judges were not simply uh, rationating from one legal principle to another and applying it to a case. The judge had an understanding of what he wanted to happen in a particular case, looking for a legal principle to say that in a way that was legally viable. And as Sam alluded to, the biggest problem with legal realism, at least as far as Derek Bell was concerned, was that there was no institutional critique built into it. And also, legal realism didn't really have a theory of race. So you have these legal realists, you have people like Oliver Wendell Holmes, you have people like Carl Llewellyn, people like Frank, who all have these uh, perspectives in the law. They really don't address the substantive racism of the law that much. Very few of them ever touched Jim Crow. Very few of them ever touched the Black Codes. Very few of them ever talked about Plessy v. Ferguson. And they couldn't really because they didn't really have the tools necessary to describe the way that race interacts with the law. They had no direct experience with it, and they had no real academic interest in it. They didn't really understand where that aspect of the law comes from. There is sort of an intuitive sense in which American law is racist, but that was typically just thought of as having been done away with once America abolished slavery and ensured civil rights and freedom. So the question for Bell then is, how do I carry forward that legal realist critique in a way that speaks to substantive racism in American law, what Stokely Carmichael would call institutional racism? How do I address the fact that America law and politics act like a racist institution because it is, right? And so those two things, those two aspects of Derek Bell's critique are the two foundational principles of critical race theory. The first one is what he calls race realism, a understanding of law that treats race as, oh, sorry, being admonished to speak slowly again. I have that southern thing where if I get on a roll, I like gradually accelerate the way I speak. If you ever watch a football coach. So the two aspects of Derek Bell's critical race theory, or at least critical race theory as it's being formed during the time period, is race realism and what he calls interest. Race realism is his belief that the law, or the way we analyze law, should treat race as a real thing. And it's important to understand what he means when he says treat race real, because we do have a sort of resurgence of race realism, which is just people, racism by another name, people who want to treat the biological reality of race real, pointing to crime statistics, IQ, black people have lower IQs on average, et cetera, that sort of thing. But what he was talking about was to treat the political, social, and cultural realities of race that oftentimes proceed on that erroneous notion of biological difference as an actual force in American law and politics, because they are tangibly observable in the way that the law interacts with people, and the way that institutions have behave when race is involved. So I have another poll I want to put up. I primed the pump a little bit, but I'm curious to see what we get. So this one is a more targeted question. Have we abolished legal barriers to racial equality? Have we successfully made it so that all formal legal barriers to racial equality have been fully abolished? And you guys. Yeah, if anything, you guys are more decided on this question or on the last. So the overwhelming majority of you guys said no. We have a few yeses. Overwhelming. So, no, we have not even successfully abolished the formal legal barrier to racial equality. So I wanted to ask you this to kind of prep you for Derek Bell's theory of interest convergence. The way that he describes interest
convergence, which is a second prong in addition to racial realism here.
Yes, exactly.
Yeah.
Yes. So the second prong is interest convergence, which is the notion that racial progress is impossible without the persuasion of the white majority that this is also in their best interest. And this theory comes about primarily from his criticism of Brown v. Board, particularly in the book Silent Covenants. The Silent Covenants he discusses are in fact what he calls essentially invisible riders to the major landmark civil rights event, the Civil War itself, the Emancipation Proclamation, and the post-war amendments. He says that the success of these comes not because the United States was in essentially a moral moment where it was reckoning with slavery, but because it was determined by a select group of white people that these things were also in their very interest. In terms of the Emancipation Proclamation, he was saying that was put forward by the interest of white plantation owners. Civil War amendments were in the interest of a Republican Congress who wanted to maintain power, especially in the South, which had just rebelled. And of course, the Civil War, which was not necessarily about abolishing slavery, was done because the destruction of the Union was seen to harm white people as well. And he carries this forward with his criticism of Brown v. Board, and additionally his criticism of the way that education, racial creation proceeded on afterwards, saying that ultimately the issue with these things is that they have primarily proceeded in the interest of a white majority, opposed to being an attack against the majoritarian of um, of the of the of the white majority. Um, Bell's sort of disappointment with the way that that civil rights movement was proceeding led him to regard this problem as essentially tractable. And it oftentimes seems kind of bleak and nihilistic for him to suggest that racism is permanent, that it's simply impossible to be successful without convincing without convincing the white majority that it's also in their interest. But this also kind of proceeds from his theory of race realism. Um, it actually begins with his understanding of a debate between W.B. Du Bois and Booker T. Washington. Du Bois is usually considered to be the good actor because he was the founder of the NAACP, Agri movement, sort of radical, the radical race egalitarian, as opposed to Booker T. Washington, who was this combination sort of race turncoat with his Atlanta Compromise, which says we will forswear racial equality in exchange for being left alone, not being lynched, that sort of thing. But Bell sees Booker T. Washington almost as a sort of double agent. He's seen as somebody who has a pragmatic, realistic perspective about the realities of race in the country, which is that we can secure white people's help in digging ourselves out of the post-slavery degradation, but that can only proceed on the basis of convincing them that they are acting in their own best interest rather than ours. So he's essentially carrying forward a Washingtonian critique of the sort of civil rights formalism, saying that these legal victories are simply not good enough because substantive racism will continue, and even the legal victories of the civil rights movement were not all they were cracked up to be, because they were at best incomplete because they failed to reckon with the realities of substantive racism. We can abolish Jim Crow, but we can't do anything about George Wallace in Alabama. We can't do anything about for example, these laws that are still on the books that are not racist in their letter, but are obviously meant with a substantive race purpose in mind. I think probably the most definitely now the most salient example of that is the 13th Amendment itself,
Mm-hmm.
which is the very text of it reads, "We have abolished slavery and involuntary servitude, except as a punishment for criminal offenses." Now we have a prison system that's overwhelmingly black. We have states that traditionally use slave labor now use prison labor
Yeah.
and things of
The
that
shift
nature.
from shadow logic to carceral logic, as Angela Davis would say.
Exactly.
One thing that's, I think, so on this claim that there's sort of two key principles, one being racial realism and the second being interest convergence. The second one I see, interest convergence, is definitely, I think, of this pragmatic Washington-esque stance. The first one, I just wanted to underscore this, is that critical race theory doesn't come ready-made. It borrows from the black intellectual tradition, and in particular from the philosophy of race that, in this case, I would say largely Du Bois presented, which is the sociological theory of race, the argument against the very notion of race as biological, as being inherently racist, so that the very modern concept of race itself was simply a way to say white supremacy. That idea, which is itself disputed, and which the philosophy of race and philosophers of race continue to work on to this day, is at the core of the racial realism idea that this is a social thing, a construct that we can find within law, within policy, within culture, and then in the second case with IC, with its interest convergence, we see this kind of pragmatism in a way. So we almost see like a Washington Du Bois uh, fusion or hybridity, which is of course not the first time we've seen this either. Carter G. Woodson's Miseducation of the Negro was in many cases trying to mediate this the debate in the 1930s between these two figures as well. So Bell joins, you might say, that conversation in the 60s and 70s.
Yeah. So he summarizes those basic narrative strains in his one of his last works, which is to suggest, which is centered around seven basic propositions. The first is that racial progress is oftentimes narrow, cyclical, and inconsistent. That we are basically getting limited victories that are oftentimes in danger of being scaled back. The second is that white support based in white self-interest is necessary for any Black victory. The third is that conflict among whites is oftentimes uh, resolved by the sacrifice of the rights of Black people, which he calls the principle of involuntary sacrifice. The fourth is that the law is extremely limited in its ability to support Black progress, especially in the courts. And this is, of course, referring back to the LDF strategy of trying to win immigration. The fifth is that racism is normal in American society and institutions. It is not aberration. It is not the result of bad actors acting with racial animus. It is simply built into the system, deeply and irrevocably ingrained in American culture, an essential element of what it means. The sixth is that Black efforts to build independent institutions are greeted with hostility and often violence, which we've seen in almost every attempt to build an independent Black community in this country. You have the city of Tulsa, which was destroyed, the city of Rosewood that was destroyed, the proposed Soul City by Floyd McKissick, which was blackballed by the Senate, the Housing and Urban Development Department. And then finally, which is the one I want to talk about last, is that ethnic and religious minorities have three choices: assimilation, unobtrusive separateness, or immigration. In other words, we have to either become a part of the fabric of American society, which is essentially a nice way of saying we need to become more white. Unobtrusive separateness, which is essentially the separate but equal argument. We simply keep to our own, mind our own business, and don't prick at the white majority. Or immigration, we just leave. We go to Liberia. So I want to make you all think for a second. Which do you think is the most likely solution to the problem of race in American society?
It's useful to note, that, by the way, in terms of Du Bois, that he gave three different answers across his life. All three of these were, he tried out all three, and his final resting place was in Africa.
Yes, exactly.
In Ghana, I believe.
In Ghana, yeah.
Yeah.
You see this art a lot with Black authors and Black thinkers.
Mm-hmm.
They start out as fans of Booker T. Washington. They become
Mm-hmm.
radicalized, and then they
Mm-hmm.
just leave. You
Yeah.
know.
Yeah. It's almost a spectrum.
Yes, exactly. Ooh, y'all are a lot slower on this one.
And more divided too.
Yeah, this is a poser. I
Yeah.
know.
Yeah, that's good. Maybe while the poll is going a little bit here, one thing that might be sort of almost too obvious perhaps to name is the point going back to legal realism and the idea that law is built on experience. Um, the fact is that people of color, and particularly African Americans, weren't their experiences weren't with they didn't live inside the law schools or the courts or and any number of things for a long time. So even those who might have had conceptually robust senses of realism, they weren't able to account for race out of their own experience. And this raises the role of first person authority and first person experience. Um, and it also, I think, makes the obvious case that a lot of what CRT is, in the same way that the civil rights movement is, in the same way that the NAACP worked out of, in the same way that Du Bois wrote about Black Reconstruction, it's what happens whenever the um, people who have been historically harmed get to have a role to play in the redress of those harms, themselves directly. So it's kind of what happens whenever people of color go and become professors in law schools instead of the students, as an aside.
All right. So here are our results. So you guys are almost split half and half between assimilation and separation. Small minority says immigrate.
Mm-hmm.
That's roughly where America was when separatism was a big deal in the 40s and 60s. Haven't changed too much, I guess. Um, but I have to admit that I'm being a little mean to y'all because Bell presents this essentially as a sort of false trilemma. This is an expression of despair at the state of racial affairs in the United States. But it was not his attempt to propose to limit our solutions to propose that these are our only options. Um, he's essentially making a theological statement here, which is essentially to say that the problem of evil in American racism is fundamentally intractable, and therefore the struggle against it itself is inherent, even if success is possible. And he is essentially giving himself a realistic view of the outcome of success. He's not giving himself a plan of action, and that was not his attempt uh, declare a sort of set of actions to other people, but rather to say that we simply have to be realistic about the way race operates. And we have to simply admit to ourselves that we live in a fundamentally racist society that's built on racism, and understand the way that permeates law and politics. So it's definitely unflattering. It's an unflattering portrait of the United States and of our history. It's not subversive in any real sense because there is no end game here. He's not saying, well, therefore overthrow white society, therefore we all just have to leave, therefore we're just gonna build a republic of New Africa, deep South, right? He's simply saying this is the reality of race in America. This is the reality of our ability to fight that with legal action, and we this is our best way of understanding the way that race operates with the law. It is more
That's
descriptive than it is prescriptive.
That's exactly the point I was going to enter in with. And this is a point we should admit, I think, of some controversy amongst contemporary critical race theorists. So there is a growing and more significant faction of critical race theorists. And even one might say, you read this in Bell's later work himself, that conceive of it beyond its diagnostic and descriptive accounts into a more full blown set of normative and prescriptive claims that translate into redress through activism and so on. It's not to say that there's anything apolitical about this, by the way, but it is to say that the critical race theory of the 1970s was really trying to find mechanisms to better understand and better diagnose and come to a more truthful account of racism, and the United States of America, which happens to be the title of his 1970 book on case law. So I think there's a real tension here, actually, on the ability to stay within a descriptive and diagnostic account of race in the law, and then on the other hand, raising questions of practice, of activism, and those kinds of things. What's important, I think, to say is that the 1970s was really a period when Bell's work was really dedicated to that descriptive foundation, and that's, I think, the part that we both want to really rescue, you might say, from the present discourse that doesn't reflect it at all.
So we have about 35 minutes. I kind of want to shift to the hypos.
Yeah.
This was a teaching tool that that Derek Bell used to sort of formulate a different way of thinking about American law. Most law professors, they use the case method, the Socratic method, to give you an appellate case and have you pick apart what the doctrine the judge is applying. What Derek Bell did was he presented a series of hypos where a formal application of the law can't really resolve the question. You have to think more substantively about the way that race operates. And you do this by presenting a complex racial issue and having everyone think through the actual issues. So we get 2 volunteers from the audience. 2 people.
We have one here I see on my screen, Camille.
Cool.
Goleb. I hope I'm seeing. I'm not sure if I'm just clicking over.
Whoop.
Oh, we have another one. Amara.
Okay.
Great.
All right. Can we spotlight the 2 of them?
I'm working on that right now.
Great.
Thank you.
And okay, sorry, working on it. Right. I need them to turn on their camera.
Okay. Yeah, if you both could turn your cameras on.
Hopefully that's not a deal breaker.
Amara, can you go ahead and unmute yourself, Amara?
Hello. I'm unable to because it says that the video is, the host has stopped the video.
Correct. And so I have to figure out how I can get you on video. Moderator 17, Janet, are you here? Can you help?
Yeah, I am, but I'm a co-host. Do you have an option to, when you look at their name, to request them to turn their video on?
No, that would have been way too easy.
All right. So presenters, if we just give everyone the power to turn on their camera and
then
do
we'll
a little
spotlight them.
test. Do you
That's
want to
fine.
do that?
Yep.
Or do we just want to have them talk without being visible?
Oh, it's fine. I think that's fine.
Which is fine, Sam.
I'm sorry. Putting on the cameras. Yeah.
Okay,
Enabling.
I will. Oh, somebody already did that, of course. So Amara, can you put your camera on now? Somebody is doing what I'm supposed to be doing. Amara, can you hear me? Amara?
Give a thumbs up.
No, I can't hear her.
Yeah.
And who's the other person?
Camille.
Camille.
Yeah.
Can you hear me, Camille?
Mm-hmm.
I can hear you.
Can you turn your
I'm,
camera?
I'm just not able to unmute or turn on my camera on my own will.
Well, that's
Hmm.
interesting because this is off.
There
Did
it
you
goes.
try again?
We could hear you speak.
It just allowed me to unmute. It said that the
Okay.
host was allowing us to unmute ourselves, but my video is still disabled.
Oh, here you go. Try it again.
Still no, I didn't get a pop-up message.
Oh, well, I changed the setting for everyone. So give it a shot.
There we go. The host has asked me to start my video.
Hi. And there's Amara. Awesome. Okay.
All right. So we can spotlight them. And then are you going to share your screen, Jack?
Yeah, I will.
Yeah.
Do you
Okay,
want me to
great.
spotlight them as well?
Yes, please.
Okay.
Hello, how are you?
How are you?
Great.
Okay. Okay, perfect. All right, so this is a hypo that was taken from the first edition of Derek Bell's case book, Race, Racism, and American Law. He invented these himself, but he bases them on real life cases. So this one says that a panel of experts has determined that racial disparities in jury composition and verdicts require the passage of the Model Racial Equality in Jury Selection Act, or Model Racial Reality in Jury Selection Act. The proposed law will require that courts ensure that juries trying defendants of non-white ethnic groups will be constituted of a racial makeup statistically proportionate to the racial makeup of the jurisdiction, with no less than 50% of the jury being made up of jurors of the same ethnic group as the defendant. The State Commission Against Discrimination is established to enforce this act and promulgate any regulations necessary to govern its use. I'm going to flip a coin. Camille, call it.
You're on mute, Camille.
Ah.
She's pointing to her head. It won't let you. Oh, there you go. Now you can unmute.
There we go. Yes, heads, please.
Heads.
It is in fact tails. All right. I would like you to. Oh. All right, Amara, I would like you to argue for this proposed law, and Camille, I would like you to argue against.
Okay.
All right, I'm gonna give you. I'll give you all about, let's say, 5 minutes to think through your points, and then I'll ask you to present one after the other. What you think? What you think the pros or the cons are?
Would you mind either sharing it again and or putting the
Yeah.
text in the chat so I can look at it? Because
Yeah.
I'll share it again.
I'll grab it and put it in the chat as well.
Awesome. I briefly need to remember your name. Sorry.
My name is Sam.
All
All right, here, I'll put it up for everyone in the chat. So
right,
folks
thank
can
you.
there we go. Wait, is it? There it is. Maybe while we're waiting, this might be a time to bring up the one of the students of Bell. There's a number of them. Richard Delgado. He is one of the interesting figures who, along with Kimberly Crenshaw, I think has really been two of the kind of strongest branches coming out of CRT, out of Bell's kind of school of thought. And he's also critiqued, you could say, his teacher and his colleagues. And CRT, of course, has a lot of inner conflict on these things. But one of Delgado's more famous critiques, published, I believe, in the Harvard Law Review on the rule of the noose, and it was an article about lynching, was a critique of what he considered the black-white binary in critical race theory. Delgado is Mexican-American, full disclosure, so am I. This case we're looking at and that we're about to hear from really mirrors the Hernandez versus Texas case that was also from 1954. And this is a case that people like Delgado, for instance, have pointed to as sort of part of the missing legacy. I think the fact that Bell wrote this in the 1970s shows that some of Delgado's criticism is not as well sorted out by some of the facts of what Bell was talking about. It's clear that Bell here is making some reference to Hernandez versus Texas, which shows us that Delgado's later critique of the black-white binary, in fact, is not a particularly persuasive idea, because this hypothetical, for instance, doesn't prevent us at all from looking at that case or at any other cases we could imagine. At any rate, I'll just come out and say that I think that Delgado's critique of the black-white binary is interesting, but it does do a little bit of damage to the way we think of Bell, because it presents civil rights law of the 1970s as a kind of retrograde, narrow lens, and I think that there's a lot of room for us to actually not see it that way. And this is a good bit of evidence to show that some of the case law that Delgado might have had in mind was in fact addressed by Bell very, very early on. So this is my quick little commercial on Richard Delgado and the need for CRT to be openly in the tradition of black radical abolitionism.
Part of why I invited him. It sounds a lot less harsh when he says it.
I tried to be really gentle.
All right.
Delgado is, of course, the editor of the Derek Bell Reader, which is such a key collection of texts and whatnot. So it's a very interesting and in some sense complex and still active scholar. So at any rate, I don't want to over-determine that critique.
All right. I think we're good here. I'm gonna have y'all present one after the other. Amara, why should we enact this law? You're on mute.
Okay, I thought I didn't have the opportunity still, but wow. I think that this law should be enacted because the piece of evidence that I found that I shared on my own personal platform says, "Dear Black people, if you are summoned for jury duty, please do everything in your power to stay on the jury. As lawyers, we need you." And a reply to this was so true. The jury I was on, as soon as we went back, they were all like, guilty. Before we left for the day, I was like, some of this stuff doesn't add up. By the time we came back the next day, they agreed not guilty. And later, we were told that he would have gotten life. So both of the speakers from the evidence that I pulled were both Black folk. And I think it's very important that what they said promotes this model racial reality in jury selection, because it's the difference between life in prison and another sentence. I hope I wasn't speaking too fast. I'm sorry.
Are the interpreters okay? Have you guys? Okay, yeah. If you're, make sure to moderate your pace if you're reading something. We were admonished for that earlier.
Rightfully so.
Yes, absolutely.
Yeah.
Okay. Yeah, that is a very, I think, organic way to approach the problem, to say that, look, there is a reality, and that's that a lot of people are going to face jail time or execution on the basis simply of where they're being tried and what race they are, and we simply have to address that issue. And one way of doing that is to make sure that people that look like them are on the jury, by whatever means we have to do that. It's a very problem-centered approach. I think that's very think about. All right, Camille, why do you think we shouldn't do this?
Unsurprisingly, very, very difficult to argue against this one. So I came up with a couple, I guess, like doubts that I would maybe be able to bring up against the way that that was written. So the first point that I had was that it was not clear what promulgate any regulations necessary quite meant. And I know that we can't always have, things spelled out for us, but wouldn't that be nice? So like, what is the scope of that commission? Like, what powers does it have? What are the, what methods to redress, whatever it finds? My second question was, I guess it kind of went train of thought a little bit. Why not require this for white people as well, or have another maybe like opposite things, like maybe you require all cases in that jurisdiction to, have a certain representation of those racial minorities, but then are you not then asking more of those minorities? And is this law therefore, putting the work back on the backs of the people it's purporting to help? It only considers race, intersectionality, implores us to make other determinants when we're considering people's life situations. Is it state or federal? And how do we have consistency if it's state? And then my last one was, if those disparities exist in those jurisdictions, there's also going to be other disparities, like, certain people having the ability to, do that jury duty without, having like financial implications or something like that. And then how do we measure the success of this? How do we know that, this law is being achieved? You know what I mean? And that's as far as I got, and that was stretching my brain.
No, I think that's very profound. You've essentially engaged in an institutional critique here of, the manner in which the law is addressing the racial problem. For example, there is no requirement of the racial composition of the commission. For example, you might have a board of all white people regulating minority juries.
Yeah.
You talked about the potential institutional burden that's being disproportionately placed on majority minority communities. There's a 50% floor of this. What do you do in a community that's only 20% Black, for instance? Are you going to have the same 5 people serve on every jury just to ensure that that the law is being enacted? A question of the jurisdiction of the enforcing. Sorry, going too fast again.
It's hard when you get excited.
I'm try to rein it in. Yeah, these are all. Okay,
I was
go
just
for
going to
it.
mention the historical example that I brought up before. So in Texas versus Hernandez, the argument made by by Texas at the Supreme Court was that Mexican Americans, Hispanics, Latinos, Latinx, whatever name my community is going by, that they were on the census at that time, non-white. They were not a non-white ethnic group because they were declared as white on the census. And so the appeal was to the letter of the census, is saying, well, Mexican Americans are white on the census, so therefore they can have all white juries. And so this is when the Supreme Court declared the class apart status for Hispanic communities. And so you can see how in this case they actually acquiesced to the statute in a way, but then they used it in a very technical pinholing way to nonetheless disadvantage the group. So that's another example of the kinds of arguments one can imagine, or that doesn't have to imagine, in fact.
It's
This
so
was
cyclical
1954.
and meta for that institution, right, to show its own racism in the way that it counts things. You know what I mean?
Yeah,
Like,
for sure.
it would.
Yeah, but the redress of that actually happened not only in the Supreme Court siding with Hernandez instead of with Texas, but also, of course, with the changes that came later on with the census and that very difficult and very institutionally racist practice we have of how we count and who counts and what counts. And yeah.
All right, that's fantastic. Thank you both for allowing me to spotlight you like that. You both did great. So yeah, be proud of that. We have about 15 minutes left. I think maybe we can do one more and then leave about 5 to 10 minutes for any questions some people might have.
Sure. We got 2 more volunteers.
Right. Yeah.
2 more volunteers for a coin flip. Don't be shy. Oh, we have one. Bob.
And in case you don't know, on the bottom where it says reactions, that's where you can raise your hand.
Oh, that's right.
I'll go grab Bob.
Okay, we need one more volunteer. Hi, Bob.
Bob.
One more.
Once again, I know you're, there we go, Fat Mindy. Awesome.
All right. Fantastic.
Wonderful. Hello, thank you for joining us. All right. I will copy paste into the chat and you can share with the screen.
All right. I'm going to do B.
Okay.
Like typo B.
Yeah.
There you all. All right. So this one is
You
actually
can unmute Fat Mindy. You have that
I
ability.
got permission to unmute. I'm unmuted.
All right.
There you go.
Awesome.
all right. This one is actually one I made. This is an actual case that I had to deal with in Alabama. No, not Alabama. Excuse me, the state of Jefferson. All right. So the state of Jefferson has had a law since the end of the Civil War that permanently disenfranchises individuals convicted of a felony. This law was deemed unconstitutional due to a clear racial animus to the law in both the composition of the prisons and the demonstrable racist intent of the legislators that passed it. Rather than completely repeal the law, the legislature has limited the offenses that disenfranchise an individual. The new limited law has also been challenged on the basis of racial discrimination, with opponents noting that while theft and drug offenses still disenfranchise, white-collar offenses do not. All right, Fat Mindy, I'll have you call the point.
Hey, what am I supposed to do now? Am I supposed to argue? Am I calling a coin flip or am I arguing
Coin flip.
something?
Coin flip, yes.
Oh, good. I'm totally qualified for that. Tails.
All right. Got tails last time. Those are good odds. Ooh, it is in fact heads. All right. All right, Bob, you're going to argue for the defendants here, and Fat Mindy, you're going to argue for the state of Jefferson. So Bob, tell me why this law is still unconstitutional, and Fat Mindy, say why it is not. All right,
now.
so I'll give you about 5 minutes to mull that over.
Maybe another commercial while we're thinking. So part of this experiment or these hypotheticals is to also like put on display some of the pedagogical approaches that we'd see Bell use. He was also an advocate of the use of fiction and fictionalization, as we see in these hypotheticals. He was a writer who wrote fiction himself. And I think that one of the things that gets missed actually in terms of what CRT has to offer the world is it has an enormous amount of pedagogical resources in terms of the teaching of law, the teaching of policy, especially within like educational contexts. Um, it's really a testimony in many ways to the power and the facility of Bell's pedagogy that CRT came to be what it is. I mean, that's kind of obvious given that his students kind of carried out the project. But we have Bell as kind of the Socrates of CRT, and so these cases and these hypotheticals allow us to maybe get a little view of what those resources look like, and the ability to replicate them if we want, or adjust them, or critique them for sure too. I think the dialogic nature of Bell's pedagogy, though, is also something that certain activist proponents of CRT should also bear in mind as well. That this is a dialogic exercise, at least within the context of pedagogy. It's not maybe as strident in its rhetorical appearance as we might think of in Malcolm X or the great strident rhetoricians of the tradition. You know.
Give it about 2 more minutes. While we're waiting, do we have any questions in the audience? We're going to have a limited time to address.
Maybe if you could start putting them into the comments, that would be a useful kind of. We could have a little bit of a log there of questions in there. Yeah.
I just opened up the chat for everyone so
Great.
they can go ahead and write it in there.
So yeah.
Oh,
Feel
that's
free
awesome.
to start
Thank you.
depositing those. And maybe, do we want to share our Twitter handles, Jack, so that if people want to take maybe pose questions or whatever, or we can go to the hashtag that's been offered as well.
Yeah, absolutely.
Go there. Yeah. Let me find that again.
ERJS2022.
Yes, thank you. I'm going to paste that down here.
Please do put in your Twitter handles.
Okay, yes.
Good thing.
Jack, is it okay if I take yours?
Yeah, absolutely.
All right. Yours is so much cooler than mine. This is not fair.
I will actually put them in the chat. Sorry, someone asked where do I find the 7 tenets of CRT that I shared of Derek Bell's. See. I was asked, how has my study and understanding of CRT impacted my own approach to law? So it's kind of been a conspiracy theory that CRT has been being taught in schools, but until my second year of law school, I didn't even know what CRT was. And I didn't even take a CRT class. I took a class called Race and American Law with Professor Jasmine Gonzales-Rose, who is no longer at Pitt. She's at Boston University now. And that was extremely influential in the way I understood the way the law works, because you're kind of hammered with this sort of formalist approach in your first year. You're kind of made to think in a particular way about the law, and kind of really conditions you to be more doctrine focused, less people focused, and kind of looking at it from the lens of my own experience with race, and also through the lens of CRT helps bring and a sort of race conscious perspective, as well as the way that the way that being a Black in the Deep South alters the way that I would see the law as opposed to a white person from the North or something like that. It's made me a little bit more self-conscious the way I approach the law in that perspective. It's less. It feels less a sense that I'm using a technician using tools, and more of, like Sam said, I'm more of a storyteller.
I have
I
an
think you're
answer
probably
to the K through 12 question, but maybe let's go to the case and then I'll offer my 2 cents on that.
sure.
A lot of my work is within the context of schools, so yeah.
Yeah. Bob, do you have an argument for the against this law here? This modified version of the disenfranchisement?
Yeah, I hope I'm taking the right perspective here, so bear with me. I got to agree with the argument. Seems demonstrably true that if you look at the imprisonment rate for drug and theft by race, that's decidedly skewed against people of color. By the same token, I have to agree that white crime, I think, is rarely prosecuted. It has to be pretty severe in order for it to be prosecuted, where drug and theft can be pretty minor, I think, as we know. The other thing that troubles me about this is the word disenfranchised. When you get that becomes I don't know how to judge that objectively. So when you start throwing that word around, if that were obvious, then we would be able to have a more intelligent discussion about election integrity, which now we're seeing a lot of movements going, across different states about that. So how to use disenfranchise as a criteria.
Mm-hmm. So the way that most felon disenfranchisement laws work is that as soon as you have a felony on your record, you are simply ineligible to register to vote or to cast a ballot. And if you're in a state like Jefferson, that usually means that you're purged from the voter rolls, and it is in fact a criminal offense for you to attempt to re-register to vote in the knowledge that you are ineligible. So when we talk about disenfranchisement, we're talking about that specifically. FemND, did you have defense of this law?
Okay, just for the record, I'd like to say that these are not the thoughts and opinions of anybody here at Batman Productions or the Pittsburgh Racial Justice Summit, because
Absolutely.
in opinion, there's no way to defend this law unless you're just completely and 3,000% a racist jag. So
yeah, that is something we should emphasize. These are teaching tools. We're not. We're not imputing these ideas to you at all.
Social media coordinator for the summit and be like, oh, that be decent. So I'm just gonna say what I've heard most racists say, which is, if you didn't want to lose the right to vote or lose your privileges, you shouldn't have broken the law. And if you break the law, then you shouldn't complain about losing your right to vote. You should have known better. That's the only thing I can say, and that's why I didn't go into law.
That is a very straightforward approach to answering the question. I think is just to say that, well, Black or not, your criminal is a criminal. So you've made a choice to break the law, and therefore you lose rights accordingly, right?
Yeah, that's the only thing. So there was no other way to defend that.
Yeah.
But still.
Well, because there's a lot of interest in this, how do you suggest advocates approach defending multiculturalist K through 12 education while distinguishing it from CRT? I wonder if I could rush to a quick kind of closing remark on this. Just in keeping with our theme of Derek Bell, I think the interest convergence strategy here is really important. One of the interest convergences of the civil rights movement was the fact that a lot of the communist countries, especially the Soviet Union, used the Jim Crow South and racism and slavery against its
Slow down a bit,
opponents.
Sam.
They used the Jim Crow South as a moral marker, as it should be, against the United States and against liberal democracy. And so there was an interest convergence in eliminating the Jim Crow South during the Red Scare. I think in the same way today, the kind of ignorance of history required to, in many cases, advocate against teaching multiculturalist K through 12 social studies curriculum or American history or so on, they're so retrograde that I think there's an interest convergence and people not being miseducated and people not being ignorant about objective facts of history. And I think there's a place for an almost shaming of this, and it'll create a backlash of elitism and whatnot, but that always comes. But I think really emphasizing that this is about academic integrity, that this is about a quality of education, that this is about truth. I think there is a strong interest convergence, whether it's in good faith or bad faith, for people not to be overtly miseducated. And I think that that's one strategy that isn't used a lot, but that could be used more. That we are
All
the
right,
rigorists, we are the academic, high standards folks.
all right, we are right at time.
Yeah.
So to respect the time of the other presenters, we're gonna drop here. If anyone had any additional questions, they can get into contact with either myself or Dr. Rocha. We'd be more than happy to answer them for you. But we're gonna have to end it off here. Thank you all for participating. This was an overwhelming response. I was not expecting anywhere near this number of people. But thank you all for sticking with us for this hour-and-a-half session, and we hope you learned something here that is useful to you in your activism work or education work or whatever you guys are doing. And